Sounds okay?
Yeah.
How about that?
Yeah.
Okay. Now, if I have one more thing, I'm out of luck, so I only have 2 hands. I kind of feel like Frank Sinatra here. I do play the piano, but I don't sing very well. But anyway, every year, thousands of disputes are resolved in our court system. And in California, where they typically go, most of the disputes that you guys would encounter are resolved in the superior courts of each county. And a small number of those cases go to trial. The judge or the jury makes a decision, and that's the end of it in most instances. In some cases, there's an appeal of whatever the decision is. And I don't know what the exact percentages are. I would guess it's probably under 20% of all the trial court decisions and judgments that end up appealed. And of those appeals, very few of those appeals have any broad significance to people in general. They have to do with problems where somebody claims a judge made a mistake, maybe he ruled incorrectly on an evidentiary objection, or he gave the wrong instruction to the jury, something like that. It's usually some technical thing. Those cases go up, the courts of appeal look at them, they make a decision, and those cases never see the light of day. But a small number of those cases have potentially broader significance to all of us out here. And those cases become published decisions. And the significance of a published decision is that once a decision is published, it means that lawyers can cite to it as effective law. People can rely on it as established statements of the law. So it has quite a bit of significance once a case is published. What that physically means is that it's certified for publication. It ends up in one of these lawyer books you always see when you see lawyers in commercials and what have you, in movies. You have these walls of books that have the same binding. Those things get bound every 2 or 3 months, a new volume comes out. I've got that in my office. With the advent of technology, that's largely expensive wallpaper these days because all reported decisions are available online, and I have services that provide them in CD. So, but how does a case get to be published? What sets it apart? What kinds of things make a case important enough that it becomes a published decision? Well, there's a number of things. First of all, every year we have all kinds of new laws. In fact, it's a source of a lot of humor, I think, in California, how many new laws are enacted each year. And unfortunately, those laws are not always very carefully drafted. So frequently, a law comes out, there's all kinds of question marks before the ink is even dry. And the way those question marks get answered and conflicts and problems resolved is that some court takes a look at it and decides what it means. So that's, and we have new statutes that came out this year, for example. There will be trials involving those laws. There will be appeals from those laws. And about 2 years from now, we'll start seeing the courts of appeal address questions and issues that arise as to those statutes. Another reason a case might be certified for publication is that it expands or contracts or eliminates an existing legal doctrine. One of the cases we'll look at this morning fairly significantly expands a listing agent's duties in certain situations. So the legislature decides what the laws are going to be and enacts them, but the courts are always monkeying with things, or either increasing the breadth of a law or decreasing it or interpreting it in some way that's different than what might have been originally anticipated. Along the same lines, a case may be certified for publication because it reconciles two apparently conflicting doctrines. You may have one law that says you need to do something and another law that seems entirely different from that. The courts will get involved, look at the situation, and they'll announce how those differing legal principles should be rectified. One frequent thing you see in cases that have been certified for publication is where the existing law or existing legal principles are applied to changing world circumstances. Probably the best example of that I can think of is what we've had in the last decade or so with the internet and the web. And the courts have had their hands full trying to apply existing notions of intellectual property and copyright and all this stuff to the circumstances with the World Wide Web. And there's my first misspelling. I know I shouldn't have done this so hastily, but another way a case gets certified for publication is if it addresses the application of existing law to some novel fact pattern. Could be we have a law in the books, and all of a sudden something new comes up, a situation nobody's ever looked of or thought of before, and the question is, how does this existing law apply to that? So that's some of the ways that a case can be deemed significant enough to be certified for publication, where it becomes law and can be relied upon. A case that came out on February 22nd, it was certified for publication, called Avalon Pacific versus HD Supply Repair and Remodel. This is a situation involving a commercial landlord-tenant dispute. And landlord leased property to a tenant. The tenant demoed it. That was part of the plan. The plan, well, it was. The tenant planned to build a Home Depot and some other facilities, had a long-term lease to do that. But what happened in this case, the landlord leased the property, the tenant took possession, demoed one of the commercial buildings on the lot, and then decided the economy wasn't very good, and he stopped. So you've got a property sitting there, it's half demolished, and you imagine what the landlord's thinking. Here, I let this guy in, and my property's half gone. So the landlord hires a lawyer and sues the tenant, saying that he caused waste to the property, and he breached the lease. Went to trial, and the landlord lost. And the reason he lost is that he continued to collect rent while the lawsuit was pending. This lease was paying like $50,000 a month. It's a big deal. And the landlord kept collecting that, didn't return the checks, didn't say, hey, tenant, I'm booting you out because you breached the lease, didn't try to get him out, just said, I'm going to sue you for all the damage you did to my property. And the courts looked at that and they said, no, we're not going to let you do that, landlord. If you're a landlord and you've got a problem like this, you need to make a decision. Either you keep accepting the benefits of the lease or you decide to terminate it, then you can sue the tenant. So the rule that comes out of that, landlord lost. The rule is, if you got that situation, you must terminate the lease and stop collecting rent before you can sue the tenant for repair costs. That's an example of a reported case that applies existing law to a fact pattern that maybe the courts haven't seen before that could arise in the future. So it provides some guidance. So if you do any property management, keep that in mind. Another case, this is probably one of the most interesting ones I want to go over today. It's Grubb Company versus Department of Real Estate. Most of the disputes that end up in our courts are between private individuals or an individual and a corporation, something like that. But a number of disputes involve the government or one of its agencies, like the Department of Real Estate. This was kind of an interesting case to me because I do a fair amount of administrative law work, and I've tried a number of cases in front of the Department of Real Estate on behalf of brokers. In this particular case, the broker was sued, and the jury came back and said the broker breached his fiduciary duties. I don't remember the exact facts, but it had something to do with square footage. There was a misrepresentation of whether or not some square footage on an unpermitted portion of a building was included in the square footage measurement that was advertised. Jury said, Grubb, you breached your fiduciary duty, but they didn't find that fraud had been proven by clear and convincing evidence. Some of you may have been exposed to this. In fact, if you've ever had jury duty, the subjects probably came up. There are different burdens of proof depending on what kind of situation you have in the courts. If you are a criminal defendant, the prosecutor has to prove that you are guilty beyond a reasonable doubt. That's like 99% likely based on the evidence that you're guilty. If you're a typical civil litigant where you sue somebody because they owe you money, or somebody sues you claiming you did something wrong in a real estate transaction, that burden of proof is called preponderance of the evidence. That's just barely over 50% you have to prove your case. Somebody has to believe it's just barely more likely than not that you're right. There is an in-between measure of proof or burden of proof out there called clear and convincing evidence. That applies to a few special situations. It applies in civil litigation if somebody's trying to get punitive damages from you. If they said what you did is wrong and you were intentionally doing it and it was malicious, whatever it might be, to get to the point where you're liable for punitive damages, the other side has to show by clear and convincing evidence that you were doing those things intentionally. Clear and convincing is somewhere between 51% and 99%, and there's not any clear guidance. But it needs to be quite a bit The reason I bring that up, and I went off on that little side road there, is that if the Department of Real Estate takes disciplinary action against you, wants to suspend or revoke your license, they have to prove their case by clear and convincing evidence. Now there's also another little rule in the law that the Department of Real Estate can utilize. If you get convicted or are found liable for fraud in a civil action, there's a special statute that allows the Department of Real Estate to come in and use that as a basis to seek revocation or suspension of your license. What happened in this case is, the jury decides that Grubb breached its fiduciary duties, but didn't decide that they did so by clear and convincing evidence. The Department of Real Estate came in and started disciplinary proceedings anyway. They came in and said, we're going to go ahead and they filed what's called an accusation, and they served it and went ahead. They had a hearing before an administrative law judge. And that administrative law judge says, you know, I don't like this. The underlying case wasn't decided by clear and convincing evidence. I don't think there should be any discipline imposed. The Department of Real Estate Commissioner looked at it and said, I don't care what the administrative law suggested. I'm going to impose discipline, and he did. I believe it was a suspension in this case. The Grubb Company didn't like that. They took issue with it. They took a writ up to the Superior Court, asked the court to look at what the Department of Real Estate had done. The Superior Court said, no, we think what the Department of Real Estate did is just fine. They took an appeal up to the Court of Appeal from there. The Court of Appeal reversed it, saying you can't take somebody's license, you can't take their livelihood from them on less than clear and convincing evidence. So basically, if there's any judgment against somebody that's just based on a preponderance of proof, that doesn't cut it as far as license discipline goes. And I don't know, hopefully none of you have ever been exposed to the Department of Real Estate disciplinary process. If you are, it's probably worth a note for a minute here how that process works. If somebody files a complaint against you, typically it will get investigated, depending on the severity of it and staffing considerations and a whole bunch of things. It may sit in a stack for a long time, or it may get accelerated, but at some point there's going to be a report prepared, and the commissioner or one of his deputies will make a decision to proceed with some kind of disciplinary action or to let it slide. If they decide to take action against you, the first thing they will do is prepare and file a document called an accusation. It kind of lays out what they claim you did wrong and what they're looking to do to you. Following that, you have some limited rights to find out what evidence they have against you, and things move pretty quickly. You get fairly soon to a hearing before somebody called an administrative law judge. Administrative law judge is a special kind of judge. It's actually employed by the agency, Department of Real Estate, and he hears these claims. And he'll listen to both sides, and he'll make a recommendation. He doesn't have authority to impose license discipline, but he makes a recommendation. A recommendation is either to do nothing, or to revoke a license, or maybe to suspend a license. That recommendation goes to the Real Estate Commissioner, and the Real Estate Commissioner makes the decision what to do at that point. And it's not over then. If you ever end up in that situation, you get to that point, things don't go well for you, you still have the right to have a new hearing in Superior Court on the charges. And if you don't like the decision there, you still have the right to get to the Court of Appeal. This particular case went through all those steps, got to the Court of Appeal, and the Court of Appeal finally figured out that no, this shouldn't have happened. And they figured it was a sufficiently important decision because it explains how the law works that they ordered the case published. Next case I'd like to go over with you is a case called Smith versus Home Loan Funding. This case is kind of interesting because I imagine a lot of you are involved in mortgage brokerage or mortgage lending, and this is a case that it's an example of what I talked to you about earlier, where a case can be ordered published because it determines how existing law applies to kind of a unique set of facts. As most of you probably know, a lender does not owe a fiduciary duty to a borrower, but a mortgage broker does. And in this case, Home Loan Funding, its individual agent started working with a borrower, and Home Loan Funding was going to fund this loan. It was going to be the direct lender, but this agent told Smith, the borrower, hey, know, I'm going to shop this rate for you. We're also a broker. We don't just fund our own loans. We have lines with various lenders. I'm going to go out and find you the best deal. And the borrower, Smith, said, yeah, that's good. I want the best interest rate I can get. I don't want a prepayment penalty. And the guy said, no, not a problem. We'll get you a loan at the best competitive interest rate and won't have a prepayment penalty. Well, home loan funding ended up funding it in-house. The evidence at trial was that the rate was several points over market, and lo and behold, the final loan had a prepayment penalty in it, so Smith sued. And Smith would have lost except for the fact that this individual represented that he was not only a lender, he was also a mortgage broker. So, lender doesn't have a fiduciary duty to the borrower, but a mortgage broker does. Home loan funding represented itself to be both a lender and a broker. Home loan funding was liable. So the rule you can take away from that case is if you're acting as a lender or a mortgage broker, make sure you don't mix the two of them up. If you're strictly going to be a lender, if you represent or act like you're a broker, you're going to have fiduciary duties to the borrower. This case is interesting because it deals with MERS, the Mortgage Electronic Registration System that acts as beneficiary under, I think, most of the loans out there these days. Sure. And there are challenges around the country to the MERS system. There's been a number of interesting cases on the East Coast. This is a challenge under California's foreclosure statutes. And this is an example of, again, kind of existing law being applied to a new set of circumstances, in this case, the MERS registration system.
$5. You know what? Is that, Bill, that's 10 for you. Your chair. That's 10.
The director.
Come on. I'll get it outside.
Gomes was a borrower. He got foreclosed on. Foreclosure was started. He filed a lawsuit in the state superior court saying, hey, you can't complete this foreclosure because I don't know who really owns my loan. I don't know what this MERS outfit is, and I have a right to have a hearing, have a whole trial on who really is the beneficiary of my loan before the foreclosure gets completed. And the court said, no, you don't. Maybe under some states' laws, maybe in other jurisdictions, but in California, our foreclosure laws are very protective of borrowers. As long as the deed of trust clearly spells out that MERS is the beneficiary or the nominee of the lender, and MERS has the rights under the deed of trust to foreclose, there's no problem with California law. So no right to stop the foreclosure, and the rule is that there's no MERS challenge in California so long as the proper language is in the deed of trust. Now the law in that area is still in a real state of flux, so don't assume that this is the last word on that. That's just one court's look at it. But next, this is a funny case. It's called Capon versus Monopoly Game. It has to do with the Home Equity Sale Contract Act. Remember a couple years ago that there was a lot of talk about that. It was all the news, and lately it's kind of died out. You haven't heard a lot about that yet, but the law is still in effect. You need to be cognizant of it. Especially if you're taking a listing, make sure if there's an NOD recorded or you think there's going to be one recorded, use the proper forms that CAR publishes for those situations. In this case, the question was whether or not an exception to that act applied. Monopoly Game's a limited liability company. It signed up to buy somebody's equity on the eve of foreclosure, but it tried to get around the Home Equity Sale Contract Act by saying, oh, we're going to live in the property. How can an LLC live in the property? And they said, well, I'm the principal of the LLC, I'm going to live in it. So the question was whether or not that was sufficient. This is a situation where a case is ordered published because a statute's vague, and it's kind of ambiguous. The Home Equity Sale Contract Act said there's an exception for, I got it here, Home Equity Sale Contract Act, exception for use as a principal residence. You said it is going to be used as a principal residence, just not the principal residence of the buyer. The court said, no, that's not going to work. It really has to be the buyer, the named buyer. And the court, the rule here that you can take away from this case is that courts are going to interpret the Home Equity Sale Contract Act very broadly and construe exceptions very narrowly to give homeowners the most possible protection from people who are preying on them when they're in foreclosure. That case just came down on March 4th, by the way. The you'll enjoy this case. The Sevis versus U.S. Bank. I imagine all of you have had the pleasurable experience of dealing with lenders jerking your clients around. This case kind of talks about how far a lender can go before they've gone too far and the courts will give them some relief. Ordinarily, as I mentioned a few minutes ago, a lender doesn't owe a fiduciary duty to a borrower, so you really can't get anywhere on that. And they really don't have any duty to negotiate with you in good faith. But here's what happened in the Sevis case. Bank promised to negotiate a loan modification if the borrower wouldn't file a bankruptcy. Actually, the borrower was already in a Chapter 7. They were going to convert to a Chapter 13 and string the lender out. And the bank said, whoa, wait a minute. Let's just work this out. We'll negotiate a loan modification with you if you don't convert your bankruptcy. Let us go ahead and get relief from the bankruptcy stay, and we'll work things out with you. The bank lied. The borrower relied on the promise. The bank ignored the promise, went ahead, gave all the notices, and foreclosed. And the court looked at this and said, wait a minute. This is going way too far, and bank's liable, and the rule you take away from this case is that an oral promise that ordinarily you'd have a tough time enforcing against a lender, it can be enforceable if it's sufficiently clear and the borrower reasonably relies on it. And those facts were present in this case. So keep in the back of your mind, if you got a client who's really being jerked around badly, they may have some recourse even if the lender hasn't put anything in writing. Real quickly, this is a funny case. Neighbors had ocean views. For years, one neighbor had a row of trees. Every year they'd get together and trim those trees and figure they'd work it out. They worked together for years like that, good neighbors. One year didn't work that way for whatever reason. They got into a major pissing match, legal term, excuse me. But they got into a fight over whether or not the trees should be trimmed and how far. The other neighbor said, wait a minute, we'll fix you, we'll show you. They went out and planted a new row of trees blocking the neighbor's ocean view. Like, I don't know how many dozens of 14-foot high trees blocking this view. So this is a situation where this case was ordered published because it applies kind of a novel fact situation to an existing law. There's a concept in the civil code called a spite fence. You can't erect a fence or a fence-like structure to harass a neighbor. And that was the question in this case. Guy plants a row of trees, clearly to harass the neighbor. The court held that a row of trees can be a spite fence as defined in the civil code. And the rule you take away from this is that a good way to spend a lot of money on lawyers.
Is that you, Joe? That's $5 back there too.
We're making a lot of money here.
You must be rich.
Yeah. The rule from this case is a good way to spend a lot of money on lawyers is to get into a feud with your neighbors, because those seem like they're always expensive fights. The last case I wanted to go over with you, and I'll open it up to some questions if you have any. Holmes versus Summer. This is the oldest of the cases I mentioned here this morning. It goes back to October of last year, but it's potentially the most significant to your practice. You may have heard about this before. There was a lot of talk on the car website and among car circles about this. This is a situation where a property owner who was significantly upside down and listed his house for sale, owed about $1.15 million, entered into a contract to sell it for $749, which is about the listing price at that time. So he's $400,000 upside down. The escrow didn't close. Surprise, surprise. The seller had planned to borrow money and get a new HELOC, borrow money from some source, pay off the loans, and he wasn't able to do it. So there was no short sale contingency, by the way, in this contract, which is an important fact. So it was just a non-contingent sale. Somehow this seller's going to get the money together to pay off these loans, even though they're several $100,000 more than the sale price. Transaction failed because the seller wasn't able to do that. The buyer sued the listing agent. Sued the seller too, but he sued the listing agent saying, hey, you had a duty to disclose to me that this guy was so far upside down in his property. You didn't do that. I got into the deal, and escrow didn't close, and I got stuck with this thing. And this is an example of a case that signifies an expansion of an existing legal concept. We all know that listing agents have some duties to buyers. For the last 25 years or so, they've had a duty to conduct a diligent visual inspection of the property they list and report any red flags that they find. This kind of expands that concept. And the case is troublesome to me because typically a listing agent doesn't owe any fiduciary duty to a buyer. But this court, it was down in Orange County, is saying, hey, if you know that there's a transaction that may not close because there's excess liens on it, you've got to disclose that. And the court said you should disclose it in the listing agreement, which is really extreme. That raises a number of issues. The court even addressed some of those. It said, somebody raised the issue, well, we can't disclose that kind of stuff. We have a duty to keep our clients' finances confidential. Why should that be out there for the public in the multiple listing system? The court said, well, you have a duty to get your seller to consent to you doing that, so some buyer isn't misled. Now, I don't know what's going to happen with this case eventually. This was not the end of it. This didn't go to judgment. It was challenged right up front when the lawsuit was first filed, and the trial court threw it out. That's the framework from which it went up to the Court of Appeal. So it's back down now in the court system. And the court's going to have to decide a whole bunch of things. Like one of the things in my mind is, well, how was the buyer really damaged? You know, they have to still prove they were damaged, even if there was some kind of a breach. But there are a few things that I took away from this that might be useful to you if you, basically the rule is whenever there's a considerable risk of failure because of the amount of loans, the listing agent must disclose. I think there's a few things you may want to do in your practice if you're not already doing them that would be a good idea in light of this decision. First of all, make sure you're real clear with your seller if you're listing their property, and make sure you advise the seller that they have a duty to disclose excess obligations that could interfere with closing. If the property's upside down, you should probably disclose that to potential buyers, even if there is a short sale contingency. If you're the listing agent, according to this court at least, you need to obtain your seller's consent to put a disclosure in the multiple listing service, or at the very least in a counteroffer when you get to the stage when you have an offer on the property. And then if you represent a buyer, you should tell that buyer, advise them that if you have a situation like this, there's sort of a seller deposit contingency where the seller's going to have to put money in to close the deal. You should do that if there's a situation where the seller represents, don't worry, if my short sale application is rejected, I'm going to go ahead and pay off the loans and close it anyway. If you're in one of those situations, make sure you have a written record that you've advised your buyer of that risk. So that's a few things of what are going on here in the last few months in the courts. Anybody have any questions? Anything you'd like to kick around?